We're here for segment 5 of lesson 16 on discharge of performance or discharge of contractual obligations. And here we're going to study discharge by operation of law. We have actually already studied parts of this. There are 6 different ways in which the obligations of one or both parties can be discharged under the contract. They don't have to perform anymore by one of these reasons. Okay. So let's just go down the list of 6. If there's been a material alteration of a contract by one party without the other's consent, then that's not permitted. You're just not permitted to, after you have a signed contract, go in and try to commit fraud essentially and change the terms of the contract without the other person consenting to that. That is treated very harshly under the law, and it basically says that's a material breach of contract in essence, or basically excuses you of performing the contract. It's a big penalty that can be enacted on the other party who has done this. The second is statute of limitations. We studied this in the past in New York. The statute of limitations for breach of contract is 6 years. For example, if you have a credit card debt and you don't make payments for 6 years, they cannot sue you after that point. They cannot file a lawsuit and recover a judgment against you if they don't do it from 6 months from the date that you basically breached the contract, from the date that your payment was due. There are exceptions to that, of course, one of them being that if you promise to pay or you actually make a payment even after the statute of limitations has run, then you're obligated to continue to make payments. So you always want to avoid that circumstance. Also realize that the statute of limitations for breach of contract varies from state to state. In a lot of other states, verbal contracts, the statute of limitation is either 2 or 4 years, and written contracts 5 or 6 years. So it can vary from state to state. Bankruptcy of a party. If either party becomes bankrupt, the bankruptcy court can set aside a contract and basically say the parties are no longer obligated to perform it. And then we come down with some other doctrines, 3 other doctrines. One of them is impossibility of performance by an unforeseeable supervening event. This is an objective test. If one of the parties dies or becomes incapacitated, if there's personal performance that is called upon, then that generally speaking cancels the contract. If the subject matter of the contract is destroyed so that the contract cannot be performed, that terminates the contract, or if a change in law renders the performance illegal. In all of these cases, if there's temporary impossibility, then that might only suspend performance. For example, if there is a partial fire and there will be a delay in when a concert can be held, and it's not an unreasonable delay, perhaps a delay of a week or so, then performance might still be required. There might be a requirement to undertake reasonable efforts to reschedule a concert or something like that. We also ask if there's commercial impracticability. Some event happens that's not reasonably foreseeable, and this event makes performance of the contract extremely difficult or costly, or frustration of purpose, where there's a supervening event not reasonably foreseeable, and the event decreases the value of what the party receives. So let's consider just briefly 3 examples. There's more examples set forth in the text. In the first example, Jane contracts for a singer, Devon, to sing in a music hall. Before the concert is held, the scheduled music hall burns down. Does Jane still have to pay Devon? Why or why not? The answer is no. There's a possibility of performance because the subject matter of that contract, which involves singing at a music hall, the music hall is no longer there. Therefore, there's impossibility of performance, and it would probably take years to rebuild an entire music hall. So, suspending performance in that case for a temporary period of time is not likely to occur. Chances are both parties will simply be excused from the contract at that point. How about this? Jimenez, a famous singer, contracts to perform in your nightclub. but he dies before performance. Has there been impossibility of performance? And clearly the case is yes. The death of a party typically terminates a contract uh, when the contract calls for the performance of that person's personal services. And lastly, this one. Josh, who is the owner of a potato farm, verbally says to you, I will deliver 2,000 pounds of potatoes to you by July 1st. Melvin says in reply, upon delivery I will pay you $450 for those potatoes. Some things ought to jump out at you right at the beginning. One is this is a contract that's governed by the Uniform Commercial Code uh, because it relates to the sale of goods. But in this case, it's only for $450. So although it's a sale of goods, the Uniform Commercial Code does not require the contract to be in writing because it's less than $500. Therefore, it is an enforceable contract. The question is, assume that a drought destroys all of Josh's potatoes. Josh can purchase the potatoes from another area of the country, but purchasing and delivering them would cost Josh $4,500, 10 times the amount that he was going to get paid for that. Can can Melvin in this case sue for damages? Why or why not? Well, we have to go back to our answers. It's not a material alteration case, statute of limitations, not a bankruptcy case, not a is it impossibility of performance by an unforeseeable supervening event? Well, it's not impossible to perform because all that was promised here is I will deliver these potatoes to you. It is still possible to deliver those potatoes. But here, we generally speaking have what's called commercial impracticability. The supervening event occurred, not reasonably foreseeable, which now makes the performance by the other party extremely difficult or costly. And in that case, it is likely that we will see basically a termination of the contract occur by reason of, in this case, a drought. Okay, that's all for this lesson. Continue to read the text, go over the examples in the text, and then go on to the next lesson. Thank you.